thank you for joining us on the Arbitration Conversation. So this time I'm really excited to have a true leader in sports arbitration, which would be very fun, I'm sure, but she'll fill us in, which is Professor Maureen Weston. Professor Weston is the director. She's a professor at Pepperdine University and works in the dispute resolution program, but she's also the director of the Entertainment, Media, and Dispute Resolution Project as well. So thanks for being here, Maureen.
Thank you, Amy. Glad to be here.
I wish I were there with you in sunny California.
I wanted to congratulate. We're doing great. And I thought first talk about sports arbitration, we'd be live from my tennis club. So hopefully there isn't too much backdrop there, but that's what I'll be doing straight after this, as usual. But I wanted to congratulate Colin and you for the new arbitrate.com series that you're doing, and also to acknowledge Jim Melamed for all that he did with mediate.com, and glad that it's going to be continuing to go strong. So very valuable resource.
Well, that's great. Thanks for saying that. That's awesome. So I guess to start off, I just wanted to get your thoughts and kind of lead into a discussion about arbitration in sports. So if you just want to give us a little bit of a background, what are the different ways that arbitration is used in sports?
Okay, well, let me count the ways because there are many. Arbitration is the primary method of dispute resolution in professional and certainly international and Olympic sports, and in commercial cases, and in college sports not as much, and that's why they're getting sued left and right. The NCAA is pretty deluged in lawsuits, but we know that arbitration is generally a private dispute resolution process in which the disputing parties waive their right to a judicial forum and empower one or a panel of arbitrators to render, after a hearing, a final and binding decision. And that private process is very amenable in the sports context when you consider the need for expertise of the decision makers, as well as the need for speed. So that athletes can get back into play if there's a disciplinary dispute. So arbitration is widely used. So obviously arbitration is by agreement and or by contract. So whether truly consensual or adhesive, that's a similar issue as consumer in the sports context, because oftentimes the players or athletes don't truly consent to arbitration. That's just the system in place. So if they want to participate in the sport, they have to agree to arbitration. And also in the commercial context, and sports is a billion-dollar industry, or at least it was until the pandemic set in. And so they're really trying, speaking of disputes, a lot are going to be generated out of the current situation of the impact of the COVID-19 situation in the sports industry, which is brought us to a standstill, but a lot of opportunities there as well. But just in terms of sponsorship, media, many of these types of contracts are among the sophisticated parties who deliberately choose arbitration as part of their process. But also in the, for example, in the International Olympic context, the Olympic Charter provides for arbitration for all members of the Olympic movement, including commercial parties. So commercial entities who are participating in the Olympics have to agree to arbitration, as well as the athletes, the governing bodies. The international sports is all about arbitration as the dispute resolution process. And that makes sense for many reasons that international commercial arbitration makes sense, because you have parties from in the Olympic context, over 200 countries. And so that to have lawsuits all over the world wouldn't make sense. And so the Olympic Charter and all of the rules of the governing bodies provide for mandatory arbitration. And that's been challenged by some athletes due to its adhesive context, but it's been upheld through the Swiss Federal Tribunal, which is the situs of the arbitration under the Olympic Charter, and it's been upheld as a fair process. Yes, sorry.
Yeah, no, I'm sure. Well, the other thing I was thinking of, well, first of all, I remember years ago when I was teaching at University of Colorado and you were a guest in my class, and my students were so
That's right.
excited because you were sharing about some of the doping cases and kind of high profile cases. I wonder if you could speak to that a bit.
Yeah, actually, that's how I got interested in the Olympic aspect of arbitration when Floyd Landis, who was the ostensible winner of the Tour de France in 2006, a week or so after he rode his bike through the Champs-Élysées, was declared to have tested positive for testosterone in violation of the anti-doping rules. And through that process, his lawyer is local in California, and they came to Pepperdine and said, would we be willing to have public arbitration? And a public arbitration had never been done before involving an Olympic sport, and it's rarely done at all. There's one new case that's been done at CAS, but we held the Landis arbitration as a public arbitration at Pepperdine, and it was quite the spectacle, to say the least.
That's very cool, though. I mean, that must have been amazing for the students, I would imagine.
Yes, and I do have, I could provide a link to that arbitration if anyone's interested. We condensed the 9 days of hearing down to a 60-minute excerpts of the arbitration, just so I can show my students what that process was.
Oh,
so that's pretty fun. I'd put a link to it.
Sounds good. So what do you see, though, in the wake of, now that you kind of brought it up, and I didn't kind of preface that I was going to ask you about this, but I do think with the current turmoil, right, with kind of the shutdown of sports, we know right now baseball, Major League Baseball is in discussions about how they're going to proceed. Do you foresee a great deal, sort of an explosion of arbitrations after COVID-19 with respect to sports?
Yes. In fact, I just did a webinar with some of the U.S. Olympic and Paralympic committee members, and a lot of the athletes now who were eligible and ready and named for to be representing the United States in Tokyo 2020. When and if Tokyo 2021 happens, is the same athlete still eligible? And a lot of the championships haven't happened yet or were unable to happen. So there's going to be a ton of, we call these Section 9 disputes because they're opportunity to participate disputes. And so who should be named, what athlete should be selected to be for the Olympic panel to participate. And so they anticipate a lot of these types of disputes because do you send the best athlete in 2020 or 2021? And a lot of athletes who are already scheduled to go had made plans to retire or go to school or start a family. So there's and a lot of their disputes about the expenses that they're incurring and the loss of sponsorship opportunities. Yeah. Oh, and then just the contracts at issue.
Oh,
force
right.
majeure questions. Who's responsible? There's a giant force majeure provision essentially in the host contract where Tokyo could be left with the entire expenses. So a lot of potential gnarly disputes in that context that will require arbitration.
Well, and how does the process work? So with all of these cases, how do they end up with an arbitrator, and how does kind of the process and cost work? Because I'm imagining for a lot of these athletes, it would be very expensive, let's say, if they had to pay for, filing fees or hiring attorneys. So is there some way to work with that?
Yes, and because arbitration is a private process, each sport has its own system in place. So, for example, if it's a U.S. Olympic athlete involving an opportunity to participate or a doping violation, the U.S. Amateur Sports Act designates the American Arbitration Association and as the designated provider, and so it's actually quite a simple process. The forms are online. You file a Section 9, or if it's a dispute among the governing bodies, then it's called a Section 10 complaint, and you file that with the U.S. Olympic Committee, And if it can't be, they actually try to mediate if it's possible. Otherwise, they go to hearing, and the AAA has a list of arbitrators that the parties can select, and they go to hearing, and it's a lot of it's happening online right now or in person. So that's from the U.S. athlete's perspective on the opportunity to participate. If it's a doping violation, you can go through that AAA process, but ultimately the Court of Arbitration for Sport is the final tribunal for all international and Olympic athletes. So that's the basically under Swiss law, and you have arbitrators who are on the AAA panel. So it's actually a fairly efficient system where they know where to go. In terms of representation, of course, the governing bodies are all represented by their respective lawyers, and the athletes not always, but they do try to have pro bono panels, and there's an ombudsman. Casey Wallace is the USOC ombudsman, and she works with athletes, not in representing them, but just guiding them to resources and guiding them to attorneys who do work in this area. So that system seems to work pretty well, just in terms of how clear the process is.
Well, and I agree with you. I think this is a perfect area where expertise and having expert arbitrators instead of generalist judges makes 100%, it just makes perfect sense, because I would imagine that you have to really understand the rules and a lot of things along those lines where not everybody would.
Yes, and so you do get, one of the critiques is you get a lot of the repeat players of the arbitrators, and so they do need more diversity at all levels in representation and as neutrals. So there's something called the Rooney Rule in the NFL, where you have to interview at least a certain number of minority coaches for general manager and head coach teams, and we might need a Rooney Rule in arbitration as well. Just because you get a lot of the same, especially at the international level, you see a lot of the same names. So that's something that could be improved upon.
Yeah, that was actually going to be one of my questions, is even just being a woman arbitrator, I would imagine that it's highly sort of a white male dominated field as far as the arbitrators go.
It has been, and hopefully there's more opening. And one thing that the pandemic and the recent events have given us the opportunity to really reflect on that and the importance of opening things up and having diversity. And Colin Kaepernick's case went to arbitration. He had a collusion case against the NFL, against the owners, saying that they colluded to try to not hire him. And the NFL has an arbitration system, so it's in the collective bargaining agreement, and he couldn't go to court on that. He had to go to arbitration and file his collusion claim with respect to that.
Well, but that raises, and this came up with the Floyd Landis as well, but it kind of creates this tension though around privacy, right? So a private arbitration, then you don't have the publicity. Right. So that's kind of the other edge of that question, I would say.
Most arbitrations, in fact, there's only been one public arbitration, the Landis case, and then in the past year, when Claudia Pechstein, a German skater, challenged the mandatory arbitration system of the Olympic movement, the European courts held that there should be a right to a public arbitration. And so there was a Chinese swimmer who recently called for a public arbitration at the International Court of Arbitration for Sport. So Sun Yang sued FINA, the International Federation that regulates swimming, and the Court of Arbitration for Sport has a website, www.tas-cas.org, I believe. It's Court of Arbitration for Sport, and they have that public arbitration hearing online as well. So we're getting a lot more resources. So that was, but most, I'm fascinated by the privacy or public aspect of that, and the lessons in advocacy and who are the real decision makers in that. So I think a lot of times that it's good theater, but the decision makers are a lot of times the new types of neutrals that you've described, and they ultimately make the ruling. So it can backfire too.
No, I mean, they're all really good issues. I think I even saw that you have an article coming out about NDAs.
Yes.
So
that one's called Buying Secrecy. And NDAs are an interesting aspect, particularly in the safe sport cases. So the safe sport cases involve questions of sexual abuse or any type of abuse that happened in sport. And the U.S. Amateur Sports Act statute was amended to require arbitration of these safe sport cases involving, for example, allegations that a coach has abused a player. And those go through actually JAMS arbitration, and there's a U.S. Center for Safe Sport. But some of in terms of the civil claims that follow personally against the coach, there have been examples of requiring arbitration. And the focus of my article is essentially a lot of the sexual harassment cases that have the NDAs. But as arbitrators, we're asked to sign NDAs as well. And that's an interesting question in terms of how much do you agree to keep confidential, and also in terms of an arbitrator, what type of indemnity do I have, what type of exposure if something gets out. So from a neutral perspective, it's something to think about as well.
Oh, 100%. Gosh, well, I promised I wouldn't take up too much time, and I know you're at your tennis club and about to play tennis, so I
hope it wasn't too loud.
No,
yes, but I could talk about sports arbitration all day. And remember, baseball has arbitration, and baseball arbitration and hockey have salary arbitration. So I'm working on a paper on how sports arbitration works, so hopefully that'll be out soon.
Oh, that's fantastic. Well, congratulations. And congratulations on all the really, really great work you're doing. I follow your articles, and I just, every time, like, what a great issue, and just really important, great stuff. So thank you very much.
Thank you, Amy. I feel the same about you.
Well, and hopefully when we're all able to travel again, we'll end up at a conference soon.
Okay, come back to Pepperdine. All right. Go Waves, go Buffs. Thank you.